Buongiorno a tutti, un benvenuto.
Good morning, ladies and gentlemen. Welcome on behalf of meeting and the Libera Associazione Forense organizing this session. I also like to thank in particular the Minister of Justice, Mr. Alfano, and the Deputy Chairman, the Deputy Chairman of the Magistrate Board of Supervisors of Italy, Mr. Nicola Mancino. Thank you very much for accepting our invitation to come here to discuss about justice, which is indeed a very serious thing. Justice is something which is needed by every man and woman, and the setup of the society and of nations depend on the ability of the state to answer to the need of justice, both for the individual person and the whole community. This indeed very well illustrates the importance of this subject. Unfortunately, in our country, it's so difficult to answer to the demand for justice. It's a situation which has been going on for years now. And justice, the problems relating to the management of justice and the reforms which are needed are just used as an element of negotiation among the different parties, and the administration of justice is used as a form of political battle, as an ideological fight. We need justice. We need a reform of the judicial system that should be the result of open discussion for the benefit of the whole country to respond to the need for justice of all citizens. The title of this session is such that it demonstrates that we can have a dialogue about justice, we can talk of justice. Before going to the gist of potential reforms of the judicial system, I'd like to ask the two speakers, what do we need as we are approaching a very problematic period of time concerning the reform of the judicial system in Italy? What do we need as a basis of a serene discussion for the common good of the country, to disregard parochial interests?
Volgo innanzitutto un saluto a tutti i presenti.
Good morning, ladies and gentlemen. I'd like to thank the organizers for inviting me here. I'm glad to have Minister Alfano here. We'll have the opportunity to discuss, and I hope we can converge on many issues. I'm aware that there will be some disagreement, but this is to be welcomed. I'd like also to welcome two distinguished members of the Magistrate Board Supervisors, Under Secretary Caliendo. We are all friends. I'd like to express him solidarity, which is a feeling which has always forged our relationship, notwithstanding different positions and stances. I don't think that politics should enter too much in the discussion about the judicial system. I think we should discuss about the judicial system reform from a different viewpoint. We should start from clearly assessing our positions in the framework of the institutions we represent. As the chairperson stated, today we indeed need to be open and available to discussion, to comparing our positions, which are different positions to which indeed we are entitled to, for we live in a democracy. From 2001 and 2006 and from 2006 to 2008, the Italian Parliament has discussed the issue of the judicial system many times. That was done starting from positions which seem to be apparently very remote and divergent, which in the end converged. If you think of the condition of the judicial system and the timing, 7 years are quite a long period. However, the judicial system turned out to be strengthened about that process for we had the opportunity to have a change of staff in the office. Many magistrates, after 8 years, were to retire. Now, then a discussion was started. I have been asked to intervene. Not all people know the members of the Magistrate Board are supervisors, the acronym of which is CSM. The CSM has been entitled to check the eligibility of magistrates. That was a decision which involved two different governments, one of the government of the period between 01 to 06, and the second government in charge between 06 and 08. At times, the discussion has been very harsh. However, I think we served the cause of national justice. Justice is a system which is indeed affected by the crisis, but this is not the only sector affected by it. In order to modify Article 111 of the Italian Constitution concerning the fact that trials should have what is known as a reasonable duration, which should not turn into unreasonable wait. That implies a lot of expenses on part of the state and on part of common citizens. The present government has always tackled the issue of the civil lawsuit, which has entered into force. And I think that the legislature has provided positive answers to that. Still, there are many issues pending to be discussed in the Parliament. there should be a discussion between the government and the parliament, as well as within the parliament, between the two political parties, or rather the government party or coalition and the opposition. Let me say that no further delays can be acceptable. Thinking of the French setup, the setup of the French judicial system, a sort of revolution which was unavoidable was implemented. Now magistrates have to continue the trial, not needing the support of the two parts in a trial. All attempts of conciliation does not mean replacing the role of the state. That means helping the state to solve the problems, being supported by lawyers, magistrates. That is the opening comment for our discussion, which I hope the Minister could respond to, so that a real turning point in the reform can happen next fall. We need a serene atmosphere to discuss very burning and topical issues. That is the entitlement, the right to have a sentence passed, and those who have committed criminal actions should be punished. Indeed, a magistrate can express their opinions on the lawsuit. Indeed, this is something which has to do with the relationship between the minister and the CSM. It is not a task of the CM to refuse certain things. It's up to the Parliament to accept or to reject certain decisions. Thank you very much.
Il Presidente Mancino ha già calato sul tavolo.
So the Deputy Chairman, Mr. Mancino, has already put on the table some of the issues that we are going to discuss today. I would like to ask the Minister of Justice what is needed in order for this dialogue to start. First of all, let me thank the organisers of the meeting for giving me the privilege to take part in this edition, which is a very important edition because it is celebrating the 30th year. It was a very very moving experience to listen to Peron yesterday. I would like to thank Mancino because he already said what is really important in order for us to start a common work for the benefit of justice and of the citizenship. And he reiterated what is the approach of the Magistrates Board of Supervisors. It has a very specific tasks. I'll just make an example. The press on two occasions said that the criminal trial was rejected by the CSM, but it is Parliament, not the CSM, that rejects or accepts a bill. I would like to be very clear because I have no philosophical aspirations. I'm a very practical and hands-on person rather than a theoretical person. And we are willing to start a dialogue and to start an exchange of ideas on this. And we have at the same time a moral and ethical obligation, which is to do exactly what we promised to our voters when we ran for this government. So we want to do exactly what we promised during the election campaign. If in 4 years' time we have elections again and we can't demonstrate that we have done what we promised, then we won't get an applause and we won't be re-elected, of course. So what is needed to do then? First of all, it is necessary to stick to the morality of politics, to be honest, of course, if you promise things and you don't hold these promises, are you politically honest? No, you aren't. This is why we still have on our website the justice program that we presented to voters 1 year ago. So look at it and you will see that there is a consistency between what we said at that time and what we are doing now. So what is dialogue for us? So let's start by saying what it is not. Dialogue is not just speaking, talking, just words, and no decisions and no action. So what is important for us is decision-making and dialogue. Parliament is the one that makes the decision after having started and conducted a dialogue with all the parties involved. So there is a methodology that has a final aim, and this final goal is decision. If there is only dialogue, only an exchange of insights and ideas, but no final decision is made, then the methodology was flawed, because decision is the final goal, and the citizen has the right to know what the decision is. So if decision is preceded by a serious dialogue, then all the better. So the methodology is based on dialogue. What is the precondition for dialogue to be concrete? That there is an interlocutor, that there is a party to discuss and to dialogue with. And we had problems with having a dialogue with the opposition. I just want to make an example. The shadow government. We had to acknowledge that we were supposed to dialogue with a shadow government, but the shadow government is no longer there, and we are still there. So this means that we had difficulties in establishing this dialogue. They set up a shadow government, but it does now become a shadow of a government. In the transition period, what happens? So it was very difficult to have a dialogue with the opposition, whose only interest was to criticize what the government was doing. So in this transition period, the opposition has just been insulting Berlusconi. So there has been no stable dialogue, and we have to consider these difficulties. And the opposition feels strong only when it denigrates the government. So, first of all, we are concretely willing to start a valuable dialogue. The precondition and the foundations of this dialogue is that our ideas are enshrined in bills and law proposals. These bills will be scrutinized by Parliament. In this meeting, I would like to say and reiterate our full commitment to dialogue. So I want from now on to give concrete proof of our willingness to start this dialogue, and I will make contact with the leader of the Democratic Party in order to start this dialogue. If the Democratic Party will have the courage to detach itself from Di Pietro and to say that at the very center of the justice process there is the citizen, I think that this is the basic point. If it will have the courage to recognize it, then we will be able to start this dialogue. So the citizen is the final recipient, is the final beneficiary of the judicial system. So there is always a victim and a culprit who, if not indicted and detained, will be able to commit further offences. So when talking about justice, we are not talking about our own interest. We are talking about the interest of the citizenship. So the heart of the problem lies in the citizen. If we will not be able to put the citizen at the center of legal decisions, then any decision, any reform will be flawed, will be wrong. And now we start talking about the specifics of potential reforms. And having here the maximum operational representative of the Magistrates Board of Supervisors, we are best placed to address this issue. The Magistrates Board of Supervisors is a venue where there can be a confrontation with politics and the political expression of the judiciary. I just wanted to bring forward some of the main criticisms levelled at the CSM. One refers to the chronic inability of self-governance, which is also dependent on the system, the political system. Those elected on the board, so the elected members on the board, cannot control what is being done and cannot act in the best interest of the people who have elected them and appointed them. And then there is another main criticism, and it refers to the so-called opinions, which are not binding. However, they sort of oppose the legislative function and legislative power, which is again an aspect which is open to dispute and is objectionable. Do you think that reforming the Magistrates Board of Supervisors is necessary, and if yes, in which manner? So what should be the main aspects of this reform? So to be honest, from an intellectual viewpoint, I must say that as far as the current government majority is concerned, and also as far as the current opposition is concerned, these issues are not political issues. I had a parliamentary experience because I was the chairman of the Constitutional Affairs Commission. I had been elected in 2006, and at that time both the majority and the opposition proposed me to be involved in the management of the Magistrates Board of Supervisors. So they proposed an appointment here. And by assuming a position that should not be based on any political parties, what happens in the opposition and in the majority is not something that is concern for me. If there are any prejudices or biases, these are issues that have to do with politics only. In 1946, those who designed the Magistrates Board of Supervisors were very smart, because they decided that all the members had to be elected by Parliament and for a term of 4 years. And they were very intelligent and very smart. 4 years may seem to be a long time in the political arena, but for the CSM, they are a very long period of time. So after this preliminary remarks, I would like to discuss the very question you asked. The Constitutional Charter is valid as far as the nature, the role and the functions of the Magistrates Board of Supervisors are concerned. And my personal opinion is that self-governance is important. However, the board's commitment is to comply with what is enshrined in the Constitution. The rules enshrined in the Constitutional Charter are not to be considered as unchangeable. However, as far as the discipline, the role and the functioning of the Magistrates Board of Supervisors, proposals are needed. I've read many such proposals. As far as some of these proposals, I've even demonstrated my collaboration. However, I think that this is a very delicate issue, an issue that should be discussed by the political forces, by the political powers and by Parliament. After the reform of the disciplinary action vis-à-vis the magistrates, I noticed that this disciplinary action has been considered as compulsory, but which is right. However, this decision was made without considering the complexities inherent in the organization of the Magistrates Board of Supervisors. Of course, there were situations that deserved sanction and disciplinary actions. However, I think that disciplinary actions are insufficient when considering the long duration of trials, the chronic delays in filings of documents and rulings. We must consider that unless there is a valid proposal for reforming the Constitutional Charter concerning the organization and setup of the Magistrates Board of Supervisors, we have to comply with what is enshrined in the Constitutional Charter. So let's now consider the various proposals that have been put forward. And let us come to the issue of the opinions that are given by the CSM. The opinion is expressed to the Ministry of Justice. So the opinion is submitted to the Ministry of Justice, and the Ministry of Justice will decide whether or not to comply with the opinion, whether to consider it. And this is a decision to be taken by the Ministry of Justice alone. And the Magistrates' Board of Supervisor is wrongly thought to be a system of ratification. However, as far as those issues which are shared, the CSM must be willing to specify that a certain issue should be accepted. However, this requires discussion also within the Parliament in the spirit of absolute freedom of thought. So I think, once again, that the Magistrates' Board of Supervisor has no power to reject reforms and proposals, because this would be an interference with the political action. So when proposing, so the government proposes reforms to Parliament. Parliament discusses the proposal by involving the other political groupings and the opposition to come to a final opinion. The Magistrates' Board of Supervisor has the goal to stimulate discussion and exchange. I think that the life of the country is not solely dependent on the majority opinions. Very often it is dependent on the opposition's willingness to act for the benefit of common good, of the civil society and the other institutions of the country. So as far as this is concerned, I've always supported this approach. I've always said that the Magistrates' Board of Supervisor has the right to express its own opinion, whether it is asked for or not, and I've always supported this conviction, even when I had a role in the government. And this is enshrined in our constitution. As far as the substantive reform which has been discussed now, I've found some proposed piece of legislation, and I've analyzed it. It is usually said that the Magistrates' Board of Supervisor is called upon to provide guarantees to the citizenship, and it must guarantee that there is a fair compensation and distribution between the number of magistrates and the number of lay people. One criticism is that the number of magistrates, there is an excessive number of magistrates, of judges. And the Magistrates' Board of Supervisor must supervise the total independence of thought and decision of judges and magistrates. If we all agree on this point, then there is much we can do to change the system and to reform the system. And I hope that the Minister will so agree with me that the number 24 is a very low number, and it does not meet the needs. shall we give autonomy to the disciplinary board as far as supervision of independence and autonomy of all magistrates? We may even have sections which are not part of the Magistrates' Board of Supervisor, and this is an idea that should be discussed in Parliament. So I propose that there are two sections of the CSM whose role is to supervise discipline, and having two sections is better than having just one. And Savonara is a member of the CSM, and he knows how much additional work this entails, in addition to all the work of the Magistrates' Board of Supervisors. So pronouncing decisions and rulings is one thing, indicting a culprit is another thing, and persecuting magistrates is a separate issue, which in my opinion deserves the maximum attention from everybody. And if an opinion is required, then the Magistrates' Board of Supervisors will surely take upon this task and express its opinion. I do not agree with the proposal of having a CSM for ordinary judges and a CSM for magistrates, for prosecutors. We should all be in agreement with the fact that the head of state should supervise the Magistrates' Board of Supervisors. I was elected as a member of the CSM in 2006, so this means that until 2010 I will take it upon myself to settle controversies and disputes between the CSM and politics. If the head of state will supervise over its activity, then there will be no need of having two different boards of magistrates supervisors. And the presidents of the Republic have traditionally a independent and unbiased role to play. And this is the point. Do we want to have a Magistrates' Board of Supervisors, a reformed one that supervises the autonomy and independence of magistrates and judges? Because this is what the country really needs.
One can be mistaken, but there are three different levels in the judicial system in Italy. The first, the second, and the third. A mistake in the court of first degree can be corrected by the second, and in turn by the third. We should consider the function and the need to have a complete structure within the system to respect the constitutional rule according to which a self-governing body should have an equal composition. I'm a lay person, as our colleague Saponara, but also magistrates have a right to vote, which is there to select different magistrates who are considered dignified to sit in the CSM. I am a lay person. I'm not a magistrate, but I think that a function foreseen by the Constitution states that magistrates should be completely independent from any other power. They should be free to decide and pass sentences, and when they make mistake, there are the disciplinary bodies which should intervene to check whether a sentence was passed in respect of the law, of the case law and the European case law. So I'm fully available to that, provided that the principle of independence and autonomy is not violated.
Signor Ministro, su questo punto.
Io ringrazio.
Mr. Minister, thank you very much, Mr. Mancino, for stressing again the style of your presidency. I'm sorry for I feel freer than you are, for you are indeed a representative of the institutions, whereas I have a political function, so you will forgive me if I'm going to say things to which you cannot directly respond. There should have been a representative of the National Association of Magistrates, for example. When we speak of the CSM, there are key important issues. The first is that of the currents within the group, the management, such as the Procuratore, the President of the Court, the Chairman of the Court of Appeal, and so on, i.e. the top management, the disciplinary legislation, the appointments. Here, instead of making some theoretical comments, I would like to start from my personal experience. Mr. Mancino and I, over the past 15 months, had the opportunity to spoke a lot in the spirit of respect and correctness and of the mutual functions that we have. At the beginning of my mandate, I was his guest at the CSM headquarters to speak about the program of my ministry. I have a very positive impression on the large majority of the members of the CSM, whom I know personally. I would be hypocritical if I were to deny some comments. I have always considered the CSM as a body which is completely disconnected from politics, and which is there to implement the function which is enshrined in our Constitution. In order to facilitate the task of myself, a young minister, Mr. Mancino, said, well, let's have a representative of each group speaking. I was grateful for that. At the beginning, well, what I saw was very odd. We had a member speaking, saying, I speak on behalf of Bob, Bill and John of AMD, the National Association of Magistrates, and the head of the group. And then a second person took the floor, and he said, I'm speaking on behalf of this and that, on behalf of James, Arthur, and another. The third did the same, and the fourth did the same. I was shocked. It was like being in the parliament, a little parliament, but it was like a parliament. So that was the starting point, which explains all. Often so we speak about the independence and autonomy of the judges, referring to the fact that the magistrate should not be influenced from outside. So as a magistrate, I cannot be convened by a politician or a friend outside the system. I have to be autonomous and independent, but not often. Not a lot is being said, but please look up at the proceedings, the meetings of the National Association of Magistrates. So this is not my opinion. This is the result of what's happening within the different currents and groups. Well, the issue of the internal independence, which is not independence from outside, it's being independent from inside. So how is it possible, it is true that nobody should influence magistrates from outside, but the same way it should be stated that the different members should be independent. So there should be no involvement of judges, so that should not be allowed for magistrates to be independent also inside, not only defended from external influences. These are two very clear risks, which are indeed very serious to the autonomy of the magistrates. The second is barely mentioned. I am fully convinced that judges and magistrates are, for the very large majority, people who are competent, who have a mission, who has passed the examinations at the law school and to enter the court. They are like all human beings. This is what I think of the majority of judges. As all organizations, there are exceptions. So it's to these good people that we should guarantee independence from outside influence and independence from internal influence. We have a voting system. You can be elected and appointed at the CSM, then you can appoint magistrates there. We have a very complex mechanism with that of appointments. It's like being in politics, and that should be avoided. We should avoid that. Let me make another example concerning the appointment of the directors. Not so very young among you might remember that the chief doctors in hospitals were all elderly people. Then it came a time when, in the framework of right to health in hospitals, a principle was adopted. You might be a very brilliant surgeon, a very good doctor, but it may be that because of that, or being that you are not a good organizer or a good manager of resources. So not necessarily you are the best person to control nurses, doctors and so on, because maybe you are not so proficient in organizing the operating timing. You are a good surgeon, but not a good organizer. So what happened is that chief doctors should indeed guarantee a good organization. So the person becoming a chief doctor should have both skills, that of a good surgeon and that of a good organizer. So the same could be applied to the judicial system, the right to healthy justice, as it were. So the top managers, the different figures, the president of the court, the procuratore and so on and so forth should always be appointed because they are the best. Not only because they are members of a group or what we call a current. We as citizens are entitled to have a procuratore which is really proficient in offering efficiency in the system. We need to have the best organizers for the functioning of the system. We indeed need that. We need efficiency. We need good organization. So the idea that the group of people, I mean people intended those having a specific judicial culture, people who can make the correct decision. So they should be a good group. They should not act as a faction or as a wing. So we need to avoid that. What I'm saying, is indeed something which can be read in the proceedings of the meetings of the different factions or currents. Indeed, we are against the abuse of being part of a faction. We are not against the diversity or the possibility to belong to different groups. What we don't like is the distortions. It's a distortion caused by the presence of these factions. When the press published stating that the CM is against the criminal lawsuit procedure, we did not reject that. It is not true. So we need a good balance of powers. It's good for the CSM to express its opinions. Opinions like it's like advice. Advice at times it's welcome, other time is not welcome. But anyway, opinions can be offered. But if when an opinion is being released on the occasion of parliamentary discussion, and if this is done to give a political connotation to that opinion, indeed, we should say that the Parliament is free and sovereign, elected by the citizens, guaranteed by the Constitution, and it's the Parliament who is there to assess the pieces of legislation, the proposals of the government. And I conclude by quoting a practical example concerning the preliminary comments on the difficulty to talk to each other. We have a specific position on justice. We think that there is no leverage to use to solve certain problems in the framework of the judicial system. We need to implement the anti-mafia rules, as we did. We need to do something for the civil and criminal lawsuit procedures, and so on and so forth. If we think of something which could be done to put on an equal level defense and the plaintiff and the lawyers and so on, indeed, we have not yet defined a clear project on that. But it's not difficult to imagine that if this is true, i.e. that we want to reform the system in order to guarantee an equal standing between defense and prosecution, in order to reform the system, as Mr. Mancino said, we need to change the Constitution. For the procedure, the procedural rules of the CSM are written in the Constitution, and that should be modified if we want to reform the system. How can we start a comparison on these issues if someone, on the other hand, says, don't modify the Constitution? Over the 60 years, the Constitution has been in force. It has been modified many times. 10 years ago, the Bi-Chamber Committee, chaired by Mr. D'Alema, proposed to amend the Constitution in the chapters referring to the judicial system. So I wonder, and this is what I publicly asked to the Democratic Party, we are ready to amend the Constitution, but that should be done based on a discussion with the opposition. But if the opposition says, don't modify the Constitution, and the only way to modify the structure of the CSM is to modify the Constitution, I mean, that's a bottleneck which cannot be solved. So I have the impression that justice has not healed over the past 10 years. Maybe the issue is not to amend the Constitution, but is who is amending the Constitution, the government or the opposition. Another important issue is the autonomy and the independence of the judicial system and the magistrates. We think that there is something which is sacred, i.e. the principles of autonomy and independence of the magistrates, that by virtue and by opportunity, an independent judge is better than a non-independent and autonomous judge. We won't do the mistake that the Christian Democratic Party did, i.e. to deem themselves eternal. One day or the other, we no longer will be at the government. So a different type of government with a different Minister of Justice, maybe they could do some damages. I think that autonomy and independence are sacred principles. Just think of magistrates depending on some political parties. Just think of that. Prosecutors who depend from certain political parties. It's better to write rules which could be just and fair also in the future. So independence and autonomy is something which is in line with another part of the Constitution. We tend to say that all the laws that we don't like are not constitutional. This is what's going on in Italy. Another defect that we have is that which follows. Considering the balance which is set in the Constitution, which is very effective in many sectors, we only quote a part of this balance, which indeed creates imbalance. So besides autonomy and independence, there is another important principle to be considered. The Constitution states that judges should be independent and autonomous, but they also state that judges are subject to the law. Indeed, that's a way to say they are not independent, not autonomous, for the laws are passed by the parliament. The parliament is composed by people who are elected by the citizens and are there to have laws respected. Thank you.
Mi accorgo che
I've realized that time is running and the issues to discuss are so many because there is a full range of reforms in the pipeline. I now leave the floor to Mancino and you can add your opinion to what has already been brought on the table by the minister. But I also invite the participants to express the opinion of the Magistrates Board of Supervisors on the proposed reform of the criminal trial, which is another important reform which is now in the pipeline. So in a country such as Italy, where there is no certainty of a penalty, where trials drag on for too long, and where if a ruling is passed after so many years, this is like denying justice. So far there has been a series of partial interventions and proposals in the wake of emergencies or in the wake of the political interest of that specific timing and moment. However, as far as some points are concerned, the opinion expressed by the CSM was very negative. So, Chairman, maybe you would like to add something to this. If you wanted to add something to what has already been expressed in the press. I would like to start by discussing this opinion on the reform of the criminal trial. And I have no difficulties expressing my opinions in this regard. I know exactly what the research office of the CSM has done. This office is made up of 6 very valuable magistrates who were appointed and selected on the basis of a very careful assessment of their curricula and of their professional experience. And I want to say that some changes were made to the document, to the opinion that was submitted. I thought that it was better for the Parliament to consider this opinion with a willingness to accept it partially, or to reject it. So the opinion that was finally passed by the Magistrates' Board of Supervisors is still a partial opinion. This is something I want to make very clear. And it revolves around 3 main points. The first point envisages an enlargement of the competence of the Corte d'Assisi. The second point revolves on the relationship between the judiciary, police and the public prosecutor. In other words, between law enforcement and the public prosecutor. And the third point, the third issue, concerns an internal assessment within the public prosecutor's office. So as far as the criminal trial is concerned, we still have to discuss the issue in full. I acknowledge, however, that approving this reform is a very urgent matter, so I will mobilize all the various people inside the board to come up with a final opinion. If we are loyal to the spirit of the reform of the civil trial, I think that the criminal trial can be made can be expedited. I was the chairman of the major parliamentary group in the Senate, and I know that the Ministry of Justice, Mr. Vassalli, at that time, he had to acknowledge that a reform that was not fully shared was better than having no reform at all. So we organized a system that was inspired by the American style, despite the differences between the Italian and the American justice system. Of course, there is an equality, and there must be an equality between prosecution and defense, but we cannot say that this equality was achieved by the reform that was made in the 90s. So I think that the criminal trial has to be reformed and rethought. And the main need is to make sure that there is a full certainty of penalty, and this will require revision of the various institutions involved. There are some trials in which the certainty of the penalty is guaranteed regardless of the conduct of the person under indictment. We live in a country where ethical and moral values are rooted in various principles and come from various sources. Italy is a country where there is a strong Catholic Church, and accordance with Catholic principles, the convicted person should be so every effort must be made in order to make sure that a detained person can become a free citizen again, of course, after serving all the sentence. Immigration, which is a new phenomenon, produces distortions in the relationship between the detained person and the structures. Every person is entitled to repent, and the society must reintegrate the repented culprit, who will have both duties and rights. Going back to the reform of the criminal trial, so I defend the school of thought according to which the magistrate should be selected by the public prosecutor. So I'm against having the citizens elect magistrates. I'm absolutely against this. But at the same time, I think that unless one wants to recognize the unlawful presence of sections and currents do exist, so we have to acknowledge this. And regardless of the commitment and the efforts that are made, current may even improve civil society. They are not absolute evil. What is absolute evil is that form of uncertainty that we feel. We feel uncertain also with regard to values that are supposed to be deeply rooted and deeply ingrained in our society. So this uncertainty is what unsettles us. So exasperated and exaggerated division in currents and factions is evil. This is true. However, we cannot pretend that by rejecting this evil we can reaffirm a new justice system. This is not sufficient. And I want to keep myself free from political interferences. I would like to come to the conclusions, and first of all I wanted to say that the much criticized Article 66 of the Constitution was written by a prominent constitutional jurist, Leopoldo Elia, who was the first signatory of this article, and I was his main supporter. I supported the fact that the simple fact that one was a member of Senate made him not liable to punishment. I was the president of the Senate at that time, and the president of the Senate must be free from political interferences. And Title V created many problems, and we are still suffering from its implications. However, Article 111 of the Italian Constitution, a change that was unanimously approved. I was the chairman of the Senate at that time, and I was asked, what do you think if we introduce the principle of a reasonable duration of the trial, and we introduce disciplinary rules with this respect? So we came at the conclusion that Article 111 could be reformed. This article is often invoked not only by the Constitutional Court, but it is also enforced by magistrates when settling disputes and cases. I think that many interesting insights have emerged from this debate. I've been listening with great interest to what the Ministry of Justice said, but as soon as I will go back to Rome and sit down to my job, I will have to make sure that willingness to reform, to make reforms, is a serious political problem. The majority has both the right and the duty to approve the reforms. And the important thing is not to be too arrogant in doing this. And I would like to use this word with reference to what Alfano said. Ghedini, when discussing the reforms of the Magistrates' Board of Supervisors, said, since nobody lives forever, I don't want to make a reform which will turn out to be unviable. So reforms must be done with a view to a long-term perspective. So this is a major point emerging from this discussion. I'm fully convinced that if we fail, if we engage in a dialogue, we can convince everybody to accept reasonable reforms. And time is needed not only to convince a majority, but time is needed to change conduct and behavior by citizens and by the government. So, regardless of the majority you have, if the voters, if citizens do not share the content of the reform, then there is no way for the reform to be fully enforced. What can we do in the best interests of our country? This is a fundamental question. And sometimes it is better to postpone reforms rather than introducing reforms which do not share a broad majority. And it is important that we are able to manage the reforms in the best possible way. And the political forces are authoritative only when they engage a dialogue with other political forces in order to come up with urgent reforms. Those reforms which are not urgent can be postponed until a broader consensus is achieved. And I would like to conclude my speech with a recommendation, with an indication. The head of state said Italy is a unique country, and the action of the government must be based on balance, and balance is what our country really needs. Thank you.
Un'ultima riflessione da parte sua, signor Ministro.
So I leave the floor to the Minister for one last observation. So you have implemented the reform of the civil trial. An important reform of the criminal trial is in the pipeline. My question is, these reforms are aimed to guarantee more efficacy of the justice system. Do they really require a revision of the legal profession?
È avvocato pure il Presidente, siamo tutti avvocati. E già questo dà l'idea.
We are all lawyers. And this already suggests that in this country there are too many lawyers. However, apart from this, this is a serious issue. In discussions with friends and other professionals, this problem is a real one because, of course, it is a factor that in Italy there is an excessive number of lawyers and attorneys, and the risk is that this will have important implications, and will deeply affect the workings of the justice system. So we have to consider this problem in the various reforms, and if interventions and actions are taken, then we will be able to see the effects in the future. Otherwise, this may have very serious problems and implications. One last point that is important is the rehabilitation of the detained person. I know that a reform is in the pipeline as far as this problem is concerned.
Mi pare tre cose.
Thank you very much. So 3 things: the criminal lawsuit, the lawyers, and the prisons. I shall endeavour to be brief. As for the first point, I have a brilliant judge in front of me, Mr. Caliendo, who is the Undersecretary for Justice, who's followed carefully the drafting of the reform. Mr. Caliendo, you became a member of the CSM at the age of 34, one of the youngest members of the CSM. So he's very indulgent and favorable in the judges. President Mancino said that that was a partial opinion. What does that mean? Do you mean that you intend to express further comments? Hopefully you already said the bad things and you are keeping the good things for yourself. Hopefully so. Well, I do believe that we'll have a lively discussion at the Parliament. There is a philosophical distinction to be considered. The criminal lawsuit is one thing. The civil lawsuit is less burning. The criminal lawsuit is something which has to do with the freedom of people being imprisoned, whereas the civil lawsuit refers to heritage, goods, assets, and so on. So these are two different things. However, for this very reason, the basic values emerge when we speak about the criminal lawsuit. For those who are part of our coalition, the primacy is in the hands of the judge, who should be a third party and impartial. Then there is the primacy of the prosecutor. We think that the most important figure is that of the judge, regardless of constitutional reforms, CSM reform, and so on and so forth. What is important is to have defense and prosecution on an equal footing. I thank Mr. Mancino very much for what he stated, and the most important jurists like Giuliano Vassalli approved of a modern code for the criminal lawsuit with the idea of equal footing between defense and prosecution, cross-examination, and so on and so forth. It was adopted 10 years ago, and the idea of having defense and prosecution on an equal footing was not respected. I'm not talking of the reason why that happened, but that should be achieved. There should be a balance between the two. I think of justice like the icon of it, the scale, with two plates. One is the prosecutor, and the second is the defense, the lawyers. So which keeps the two plates in balance? All the icons of history, both the Christian icons and the popular icons of justice, the two plates are always in balance, not like that. So which keeps the two plates in balance? It's the defense and the prosecution lawyers, and at the center we have a hinge, which is the judge, which keeps the balance. So if the judge is not at the same distance from the prosecutor and the defense, an imbalance happens, and the one who bears the cost is the citizen. So that balance should be guaranteed with an equal, fair trial, which is fast and with a balance between prosecution and defense. So this is the objective that we have to be achieved. An equal trial is there when the balance is between defense and prosecution. The fact that the trial could be very long is wrong. For a sentence passed after 15 years is a wrong sentence which has denied the right to justice by plaintiff and defendant. But a very fast process with unbalance between defense and prosecution brings about a wrong sentence as well. So we think that fast and just process. As for the criminal lawsuit,
so the relationship between the public prosecutor and the attorney. We have the false idea that the public prosecutor won a competition to exercise justice, and that there are many policemen or inland revenue officials who have won a competition to search for culprits and offenders, and are fully trained to exercise these actions. And we also have an idea that there is a team which is made out of government officials, policemen, law enforcement officials, and that this team is called the state. And this is why we do not accept the idea that some magistrates think that giving powers to law enforcement officials, for example, policemen or inland revenue officials, is something which should not be done. So we want to express our estimate for policemen and law enforcement authorities who are working every day in our country, because they fight against organized crime on a daily basis, and that they search for evidence and submit this evidence to the public prosecutor. And the public prosecutor, if the conditions are satisfied, bring together this evidence and bring them before a judge.
Questo è lo schema, per cui fanno passare come eversivo che cosa?
So they speak of a division of functions between the police and the magistrates. This is being jealous. This is stupid. This is not constitutional. I think that the Constitution has been really very performance since its adoption. The lawyers and their structures. I met a European delegation in Rome coming to check the judicial system in Italy, and they told me one of the reasons why the trials are lagging behind. That's due because we have too many lawyers. Because of this backlog. So the more lawyers you have, the more they search for customers, the more they create trials. I didn't oppose that position. I am a lawyer myself, so I told them that indeed we are very Mediterranean, and so we are very fightful in spirit. But having too many lawyers, can that create an excessive number of trials? On the 28th of August last year, I'm just appointed as a minister, I convened lawyers, notaries and accountants in my office. For I think that there should be a complete reform in the judicial and economic systems in certain professions. Otherwise, we won't be able to reform the judicial system. As Mr. Tosoni said, I mean, you need to modernize the professions which are part of the judicial system. So I asked lawyers to propose a text of reform which is shared by your categories. I mean, there are so many lawyers, so that indeed I'm young, but I think I understand. I know what to do in politics. Instead of proposing a reform to be rejected by many people, I asked them to be involved. After 10 months, a good draft text was proposed. And at the Senate, the text was presented, and I asked to use principles in that text. So the lawyers is not longer to be in a court, or being a barrister should not be the working choice of those people who got a university degree at the law school but did not find any other job. So if one wants to be a defendant, that should be a mission. There should be a careful selection of that, so that we have young, modern professionals who can really exert their job. I mean, you have to plant seeds and which will bear fruit in the future. That means having a modern group of professionals which is up to the time of globalization. And in Italy, people go to the lawyer and go to the lawyer by choice, and because they select the person they want, and they trust lawyers in Italy. This is good, and that should not be neglected. This is what we want to safeguard, because we don't want to throw away the baby with the water. Prisons. There are about 63,000 people sleeping in our prisons. There are 43,000 beds. That means that the prisons are overcrowded, and that number was decided based on the potential number of Italian criminals, but we now have criminals coming from abroad, and there should be a further 20,000 places in the prisons. So, to be practical, I just wondered how that problem was solved, as Mr. Mancino said. I mean, the issue of overcrowding, how was that solved in the 60 years of history of our republic? I called my office and I asked them, how was that issue solved from 1948 to 2007? In 60 years was the answer. We had 30 sentences of amnesty passed. So the solution is either we do the 31st, the last was in 2007, so 20,000 people will be released and so on and so forth. That's one of the possible solutions, i.e. Releasing 25,000 prisoners every 2 years. We decided to do something different, which reconciles the need to guarantee security and safety to citizens while respecting the dignity of human beings. The judicial system should not be inspired to revenge. We need to punish those who are culprits, but we think that a person can be born to a new life after being imprisoned. And I'd like to thank the head of prisons in Italy, Dr. Ionta, and the 40,000 people of the prison police who work in the prisons. They stay in the prisons not because they are criminals, and also they have low pays, so I'm very grateful to them for what they are doing. I also like to thank the members of the Radical Party and the 100 members of the politicians from Italy and Europe who traveled to different prisons to see what the situation is, and now they share the same position that I have. So in order to solve that problem, we need a new approach, which is based on two things and some preliminary comments. The two elements are building new prisons so that prisoners can live in a dignified there, and job training in prison for prisoners. There's an economic and financial crisis, you know. For that reason, we indeed had to make cuts. That was following an agreement with the managers. In one field, I asked not to have cuts and good projects to be supported, i.e. to train prisoners to a job. And there are indications of that outside. So one thing which can avoid persons committing again criminal activities is to learn a job. So when they come out from the prison, they have a new job in the hands, and they follow a different road in their life, and they will not commit crime any longer. So if you want to re-educate, retrain these people, we need to have support. I could speak for that for a long time. First of all, the issue of pre-trial custody. Then we have a serious problem. We know that if we build new prisons, the problem will be partially solved, and then we'll implement job training. I was a bit impressed by a sentence condemning to pay €1,000 by the Court of Justice because a person from Bosnia who had been imprisoned and who brought us to court because the prison room was too little. But Europe is condemning us what we are paying for that person, and they don't care the fact that we further have 20,000 foreign prisoners, and they don't care of that. It's not because we are to be blamed. It's not our fault if we have the Lampedusa island where a lot of people come. It's not the fault of Italy or Sicily or Lampedusa. So either Europe accepts that there is a new issue there, and the migrant flows of today are indeed different. So if we calculate the number of foreign prisoners in Italian prisons, the number of beds is right. So either Europe intervenes by signing new treaties and monitoring compliance with those treaties of all the countries on the Mediterranean Sea, or they give us the money to build new prisons, or indeed, Europe cannot think of passing fees and levelling sanctions against us. So this is the problem to be solved. And Mrs. Bonino, whom I esteem very much, stated that this is not a task of Europe. I'm a convinced person. I believe in Europe, and if it were like that, like she says, that would also mean that there is someone who has to take that problem on board.
Ringrazio i due interlocutori, soprattutto.
Thank you. I would like to thank our two guests for two reasons. The only fact that they are here with us is an important signal. It gives us reassurance, and we really hope that this autumn will be characterized with by reforms that will actually be in the best benefit, in the best interest of the citizenship and of common good. And then there is a second reason. The institutions, the political institutions, have to face a reality and have to ask themselves questions on how to improve reality. As far as prisons are concerned, it is important that the reality is being faced and that action is taken in order to change it for the better. And this is a different approach, an approach which is independent from political stances. And this is a role for which we are all called upon to take on responsibility, and I hope that the reforms will be implemented, and will be implemented in the best possible way for the best